Hello. In this short presentation, I'd like to cover the basic principles of the criminal jurisdiction of states. So, there are a number of topics we'll cover in these slides relatively quickly. So, I want to look at the difference between prescriptive, adjudicative, and enforcement jurisdiction. So the authority to make rules, the authority to judge rules, and the authority to enforce rules, each of which is potentially important to us. Then we'll look at the idea of prescriptive jurisdiction based on links. When can a state legislate that a crime exists within a national system? And we'll focus particularly on universal jurisdiction to prescribe. When may states pass laws applicable to conduct committed by anyone, anywhere in the world, irrespective of any connection to the prosecuting state? And then we'll look briefly at the idea of treaty-based systems of so-called quasi-universal jurisdiction. So this is common in relation to terrorist or transnational offences, particularly, say, the provisions in Article 6 and 7 of the Convention Against Torture, where states come together to pool their jurisdiction to try and prevent there being impunity for certain particularly heinous crimes. Now, these questions of universal jurisdiction and treaty-based jurisdiction, in the absence of ordinary links to the prosecuting state, are particularly important when we come to look at the jurisdiction given to treaty-based courts, like the International Criminal Court. All right, so let's look at jurisdiction based on so-called links. So the easiest idea here is that a state can prescribe the conduct, can pass rules governing the conduct of its nationals. So this is called active nationality. So whatever, for example, an Australian does anywhere in the world is potentially subject to Australian criminal law if the relevant Australian parliaments have so enacted. Similarly, passive nationality jurisdiction is increasingly accepted, which is to say that if an offence is committed against a Belgian and the state of Belgium can secure in custody the offender, then Belgium can prosecute that offence even if it was committed outside Belgium. So if an Australian assaults a Belgian in Canada, so long as Belgium can secure the extradition of the Australian, it could prosecute that assault or murder even though the offence occurred in Canada. So active and passive nationality jurisdiction are two principles by which states' criminal law will often extend beyond their territory. Which brings us to the idea of territorial jurisdiction. So we would say it's fairly obvious that a state should have jurisdiction over events that occur within its territory. But what about events or crimes that cross borders, transnational crimes, particularly crimes such as, for example, drug smuggling? Now, the classic example usually given in lectures is the idea of someone shooting another person across a border. So again, we might have in this scenario on a border between the United States and Canada, a person standing on the United States side of the border shooting someone on the Canadian side of the border who has territorial jurisdiction. Well, the answer would be where the offence is completed, where the murder or wounding or assault took place, would be the state of objective territorial jurisdiction. The physical elements of the crime were completed there, but the crime was commenced. The mind governing the crime, the guilty mental state, was found in our example, the United States, where the gun was fired, and that would be said to be the state of subjective territorial jurisdiction. So again, both territorial jurisdictions could have jurisdiction over the entire offence. Now, one might say, okay, well, nonetheless, surely a territorial jurisdiction should trump or prevail over a nationality jurisdiction, or the objective territorial jurisdiction should always be able to prosecute a crime, and the subjective territorial jurisdiction should defer to that. Actually, all these principles are equal. There is no rule of priority. Multiple states may have concurrent jurisdiction to prosecute a crime. Further, there is no absolute rule in international law against double jeopardy, multiple prosecutions for the same offence. But as a matter of practice, states will normally only prosecute particularly serious extraterritorial crimes because of the expense and the difficulty of gathering evidence. And ultimately, states are usually, even if they have provision for trial in absentia, are often not particularly keen on conducting something as expensive as the trial unless they have the defendant actually in custody and are in a position to do something about them. So very often the question of priority over a crime will be resolved by who has the defendant in custody. There are a number of other concepts we should note. Effects jurisdiction is known largely in economic law. It's the idea of activity abroad that influences your national jurisdiction. In terms of criminal activity, the classic one for effects might be, for example, currency forgery, because releasing a large number of fake, for example, euros or US dollars into circulation internationally could affect the value of that currency, even if the forged currency never moves inside the relevant jurisdiction, if it only circulates in the wider world. So that might be one example, but largely the effects jurisdiction will overlap with objective territorial jurisdiction for our purposes. There are a number of special cases where objects or people are the object of special extraterritorial jurisdictional regimes. So a vessel on the high seas is subject to the exclusive jurisdiction of the state whose flag it is entitled to fly. So this could be called flag vessel jurisdiction, and it crops up in treaty-based arrangements, including the Statute of the International Criminal Court. So an offence committed on a vessel on the high seas will be treated in much the same manner as an offence committed on the flag state's territory. That is not to say that a flagged vessel is territory in law. It is not a floating piece of territory, just that for certain criminal law purposes it can be treated as if it were territory. Also, separately from the nationality principle, states have jurisdiction to regulate the conduct of their armed forces abroad, even where members of that armed force are not their own nationals. So foreign nationals, for example, can join the British or US or French armed forces without necessarily having nationality in the UK, the US or France. All right, that brings us then though to universal jurisdiction, the most important or popular perhaps concept in jurisdiction and international criminal law. So the first idea is universal jurisdiction to prescribe. When can states prescribe conduct? So just turning back to an earlier idea, we're still talking largely about prescription here. So the passing of rules that your courts can adjudicate. This needs to be distinguished from enforcement jurisdiction, the ability to, as it were, use your executive powers, your police, to enforce rules and particularly to take suspects into custody or to seize evidence. Now, we've been talking about quite a number of cases where jurisdiction to prescribe is extraterritorial, but that doesn't mean there's extraterritorial enforcement jurisdiction. In my example of an Australian murdering a Belgian in Canada, while on Canadian territory, the only valid enforcement authority obviously belongs to Canada. There are certain exceptions to the territorial limitation of enforcement authority, usually granted by treaty, such as sort of cross-border police pursuit arrangements, for example, within Europe, or rules of intervention against foreign ships on the high seas in cases such as piracy. But while jurisdiction to prescribe is commonly extraterritorial, jurisdiction to enforce is only exceptionally extraterritorial. So let's come back to universal jurisdiction to prescribe. So the essential idea here is that universal jurisdiction is simply jurisdiction that exists in the absence of ordinary links, so those we've already talked about. So the question then becomes, well, in respect of which offences may a state assert universal jurisdiction to prescribe an offence and then to adjudicate it if it can somehow gain custody of a suspect. So on that question of which offences are covered, certainly the core international crimes we'll look at in this course are said to be subject to universal jurisdiction. So war crimes, crimes against humanity, genocide, and perhaps the crime of aggression. Certainly one might also add to that piracy and perhaps offences such as torture and more marginally perhaps slavery. But once one moves beyond the core, there are sort of more complex questions of evidence about the existence and nature of universal jurisdiction. So the first question we always have to ask is universal jurisdiction in respect of what? And do we mean universal jurisdiction under custom, or universal jurisdiction in the sense of jurisdiction in the absence of links, ordinary links, which might be provided by a treaty system of the kind we'll talk about next. The next question is, just because you've got universal jurisdiction, does that mean you must exercise it? If you have a genocide suspect on your territory, must you attempt to prosecute them? That is universal jurisdiction mandatory? You must do this, or merely permissive? You may do this. Well, insofar as we're talking about a rule of customary international law and examining what states do in practice, it's pretty obvious that states are not continually attempting to assert universal jurisdiction over international crimes committed everywhere in the world by whoever may have committed them, and are not necessarily even that keen to assert universal jurisdiction over persons who come within their territory. So on the basis of state practice, it would appear the rule is permissive rather than mandatory. This leads us to the other big controversy is, can you only exercise universal jurisdiction? Can you only commence an investigation or prosecution if the accused is physically present in your territory? And this leads to a confusing debate that we'll examine in class about the idea of attempting to assert extraterritorial enforcement jurisdiction in respect of universal jurisdiction. Put simply though, if a state cannot take preparatory steps like opening an investigation and beginning to gather evidence before someone suspected of a universal jurisdiction crime is on their territory, it's going to be very difficult to issue an arrest warrant for them in a timely manner. Further, if one requests another state surrender to you a suspect in a universal jurisdiction case, that is not extraterritorial enforcement. That is simply asking for some cooperation in order that a prosecution might occur. So if one says that somehow you can't do anything under universal jurisdiction until the accused comes within your territory, then that kind of international cooperation is defeated as well. Now, the idea of universal jurisdiction, and particularly commencing prosecutions or investigations against people who are not in your state's territory already, does raise a number of concerns, and it's occasionally alleged that this could endanger international diplomacy or lead to people being the victims of politically motivated prosecutions and hounded through all the courts in the world. But we can ask whether in practice that seems a realistic fear. We then need to come to the idea of treaty-based or quasi-universal jurisdiction. So this is, as it were, a system where states may club together to share their territorial jurisdiction and say, you may prosecute a crime committed on our territory or against our nationals or by our nationals if you can secure jurisdiction over that person, or if you find them within your territory. So if you look at Articles 6 and 7 of the Convention Against Torture, it lays out that parties to the Convention Against Torture are under an obligation to, if they have someone suspected of torture within their jurisdiction, and if the circumstances so warrant, take that person into custody, commence an investigation, and notify other states who are parties to the Convention who might have an interest in the case that they are looking into it. then, under Article 7, that state party has to make a decision. Will they prosecute that person themselves or extradite them to another state for prosecution? And if they choose national prosecution, they have to have a national law that allows the prosecution of that individual, even if that individual is not their national, and even if that individual's crime of torture was committed outside their territory, so long as either the suspected torturer, the suspected victim, or the territory in which the act occurred are covered by the jurisdiction of a member to the Convention. So it's a system, as it were, of pooling or cross-vesting or mutually delegating jurisdiction. And that same sort of jurisdictional basis operates to some extent in the International Criminal Court statute. The International Criminal Court is not given universal jurisdiction, it's given jurisdiction in respect of its member states' nationals, territory, and events occurring on member states' flag vessels and aircraft. All right, that concludes our review of principles of jurisdiction, and the next of these short presentations will go to questions surrounding the purposes of international criminal law. Thank you for your attention. I hope you join me for the third of these presentations. Thanks.